There was a photograph on the evidence table, 8 by 10, printed on plain paper. It showed a white Porsche Cayenne parked across a flat gravel clearing, and 40 feet behind it, a man on the ground with 3 people trying to keep him alive. I looked at that photograph every day of the 3-day trial. I still think about it when I cannot sleep. This is that case. I have been on the bench for 22 years. I have presided over more than 3,000 cases. I have seen people lie to my face with such ease I had to stop assuming I could always tell. I have seen grief and greed and the particular kind of shame that only arrives when consequences finally meet behavior. But that photograph, a man on the ground, a car in the way, that is the one that stays. Before I go further, I need you to subscribe, not as a formality, because there is one piece of evidence in this case, something small, something that almost did not make it into the record, that changed the entire direction of my ruling. I want to make sure you are here when I get to it. Subscribe now. Let me tell you about Marcus Webb first. He came into my courtroom on the second morning of testimony. He had been in the hospital the night before, and his doctor had cleared him to travel with conditions. He walked with a cane, not the kind people use when they are performing an injury, the kind someone uses because their left leg does not fully close the distance between steps anymore. He was 53 years old. He wore a gray suit jacket that did not quite fit at the shoulder, and later I understood why. His left shoulder had been partially reconstructed after the cardiac event. He sat down slowly. He did not look around the room the way people usually do when they arrive somewhere unfamiliar. He looked at his hands. I noticed one specific thing about Marcus Webb. After his attorney finished asking him questions, after he answered everything he was asked, he turned slightly toward the defense table. Not aggressively, not dramatically, and he just looked at the woman sitting there for about 4 seconds. He did not say anything, then he turned back. I have seen that look before. It is not anger, it is something closer to not understanding. The kind of look a person gives when they genuinely cannot make sense of another human being. Now, the woman at the defense table. Vanessa Alcott Pierce came into my courtroom on the first morning wearing a cream blazer and shoes I later learned cost $1,400. I'm not telling you that to make a point. I am telling you because it is what I observed. She sat at the defense table with her hands folded and her spine completely straight. She did not look at her attorney when he spoke to her. She looked at me. From the moment she sat down, she looked at me. I am familiar with this approach. Some defendants are coached into sustained eye contact with the judge because it signals confidence. What I noticed was that she never looked at Marcus Webb. Not once on the first day. Not when he walked in. Not when his name was said out loud. She kept her eyes front and her chin level. That told me something. Not what I was allowed to rule on, but something. Her husband, Daniel Alcott Pierce, had worked in investment banking for 19 years. He was not on trial. He sat in the gallery on the first day in a charcoal suit and left before lunch. I saw him leave. I noted it. What happened on July 14, 2023 was reconstructed for me through 7 witness statements, 2 expert reports, aerial footage from a neighboring property's security camera, and the testimony of 2 emergency medical technicians. I was not there, but I have been told about it so many times in such specific terms that I know the shape of it the way I know a room I have visited many times before. Marcus Webb was 62 yards from the landing zone. He had been playing golf at the Sycamore Ridge Country Club in Westport, Connecticut, on a warm Friday morning when he collapsed at approximately 10:47 a.m. The paramedics who arrived by road made their assessment within 4 minutes. His left anterior descending artery was blocked. They called for helicopter transport at 10:54 a.m. The designated emergency landing zone at Sycamore Ridge was a gravel clearing behind the maintenance shed. Cleared, marked, kept open under county regulation for exactly this kind of situation. The club had registered it with the county in 2019. Every member had received written notification. Vanessa Alcott Pierce had been a member since 2020. She had parked her white Porsche Cayenne, valued at $97,000, in the center of that clearing at 10:12 a.m. The helicopter was inbound at 11:03 a.m. The pilot radioed that the zone was obstructed. The club's head of grounds went to find the owner. He located Vanessa Alcott Pierce at the women's lounge at 11:06 a.m. He told her a medical helicopter needed the landing zone. She said, and I am reading from his sworn statement exactly as he gave it, "I am not moving it. It is the only shaded spot and the paint will blister." The helicopter was rerouted to a secondary site 1.4 miles away. The additional transit time was 11 minutes. Marcus Webb received the intervention he needed. He survived, but the 11-minute delay caused what his cardiologist described in testimony as permanent damage to the left ventricular wall that would not have occurred had the helicopter landed where it was supposed to. He will take medication for the rest of his life because of those 11 minutes. If you are the kind of person who stayed with this story this far, not because it is dramatic, but because you actually want to know what happened, then you already understand why I am telling it. Subscribe. This is what I do now. Tell the stories that need to be told. The legal process that brought this case to my bench was not simple. The charge required the prosecution to establish something most people in the gallery would not have anticipated: criminal interference with emergency medical services operations. In Connecticut, this falls under Section 53A 167A of the General Statutes, obstructing emergency personnel, and the specific application to a designated emergency landing zone had not been tested in this court before. There was a procedural motion filed by the defense in the first week attempting to have the charge reduced on the grounds that the defendant had not been formally notified in person on that specific day that the landing zone was active. I denied that motion. The regulation does not require real-time notification. The marking on the ground was sufficient. The membership letter was sufficient. The county ordinance was clear. There was one additional charge: reckless endangerment in the second degree. That one was straightforward. Now here is the thing I want to tell you. The third day of testimony, the moment I had to ask the witness to repeat himself. The prosecution called the helicopter pilot, James Theriot, 27 years of emergency medical aviation. No incidents on his record. He described the reroute in technical terms, but then the prosecution asked him whether, at any point during the reroute, he had been able to see the obstructed landing zone from the air. He said yes. He said he had flown directly over it. He said the vehicle was visible from altitude, and then he said that as he flew over, he could see two people running toward the vehicle from the direction of the clubhouse. He said one of them was a woman in light-colored clothing. He said the vehicle did not move. She was outside. She saw the helicopter fly over. She did not move the car. I asked him to repeat that last part. He did. I wrote it down. From my position at the bench, in my peripheral vision, I watched Vanessa Alcott Pierce's right hand go flat on the table. Just flat, still. That was the only reaction. I want to stop here for a moment, because what I am about to tell you is the part of this case I had to sit with the longest before I felt ready to speak about it publicly. Subscribe before we go further, then take a breath, because this next part matters. The evidence came in 3 waves, and I want to describe them the way I experienced them because the order matters. The first wave was factual and clean. The landing zone registration documents, the membership notification letter dated March 3, 2021 with Vanessa Alcott Pierce's membership number on it, the aerial security footage showing the Cayenne entering the clearing at 10:12 a.m., the helicopter dispatch log, the timeline. These established the framework, solid, uncomplicated. The second wave was the defense's attempt to introduce complexity. Forsyth, her attorney, Richard Forsyth, whom I have seen in my court several times, called a car restoration specialist who testified that direct sunlight on a light-colored vehicle in July temperatures can cause minor clear coat oxidation. True. He called a parking lot attendant who said the regular members' lot had been partially closed that morning for resurfacing and that overflow arrangements were, in his words, confusing. Also true. Neither of these things established that she had not been told about the helicopter. They established inconvenience about parking. That is a different matter entirely. Between the second and third waves, I noticed Vanessa Alcott Pierce write something on her notepad and slide it to her attorney. He read it, nodded once, and did not respond. I do not know what it said. I only know what I observed. The third wave was Theriot's testimony, which I have already told you about, and which changed everything. I have been doing this for 22 years. The cases I choose to talk about publicly are the ones I believe need more people to understand. Subscribe and tell me in the comments what is hitting you hardest so far. I read what people write. It matters to me. The defense argument in closing was, I will give it this, organized. Forsyth argued three things. First, that establishing deliberate obstruction required proof of intent, and that his client's intent was to protect property, not obstruct emergency services. Second, that the 11-minute delay could not be causally linked with certainty to Mr. Webb's permanent cardiac damage. Third, that reckless endangerment required the defendant to have been aware of the risk she was creating, and that awareness, he argued, was not sufficiently established. I considered all three. I gave them the weight they deserved. On the first, the statute does not require intent to obstruct. It requires the act of obstruction. She obstructed. On the second, the cardiologist's testimony met the standard of medical probability, not certainty. Medicine rarely offers certainty, but probability, which is what the law requires. On the third, a woman who received written notification of the landing zone, parked in a marked emergency zone, was told by club staff that a medical helicopter needed that space and then remained outside visible to that helicopter as it flew overhead. That woman had awareness. What she did with that awareness is what we were there to answer. Vanessa Alcott Pierce took the stand on the afternoon of the second day. Her attorney asked what she was thinking when the groundskeeper approached her. She said, I assumed someone would handle it. I wrote that down. I do not believe she was lying. I believe she genuinely assumed the situation would be handled by someone else, someone whose job it was, someone who was not her. That assumption is not a legal defense, but it is a true thing about who she was in that moment. The most honest record of a case includes the true things, even when they do not help the person they describe. She also said on cross-examination, when asked whether she believed emergency services were more important than her vehicle, "Of course I do. That goes without saying." She said that. I wrote it down too. I have a personal connection to this case that I did not disclose on the record because it had no bearing on my legal reasoning, but I am telling you now because I said at the start that I am telling you the truth. In 2009, my younger brother had a cardiac event in a parking lot in New Haven. He was 41 years old. The ambulance reached him in 6 minutes. 6 minutes was enough. He is still alive. He has 3 children. He coaches his youngest daughter's soccer team on Saturdays. I think about those 6 minutes sometimes. What a different number would have meant. I did not think about my brother during the trial in any way that affected what I decided. But when Marcus Webb sat in that chair and said quietly, not performing anything, I keep waiting to feel like I did before and I don't think that's coming. I heard that sentence in a way that had nothing to do with the bench. I just sat with it for a second. Then I kept working. I had made my decision before the closing arguments were finished. I want to be honest about that. I had made it when Theriot described watching that car sit still while he rerouted, but I let the process complete. That is not indifference. That is what the process is for, to make sure every argument has been made and heard before a life is altered by the person sitting where I sit. The room when I returned from deliberation was quieter than most rooms I returned to. That kind of quiet has a texture. It is the quiet of people who have already decided how they feel and are just waiting for permission to feel it out loud. Vanessa Alcott Pierce was standing, her attorney beside her. She was looking at me, the same steady way she had looked at me since day one. Her hands this time were at her sides, not folded. Marcus Webb was in the second row of the gallery. His wife had her hand on his arm. He was not looking at me. He was looking at the floor in front of him. I said, "Guilty on both counts." The first reaction I noticed was not from Vanessa Alcott Pierce. It was from a woman 3 rows behind her, a club member who had testified earlier, who closed her eyes and exhaled slowly, like someone who had been holding their breath for a very long time and finally remembered they were allowed to stop. The verdict was not the hardest part of this case for me. The sentencing was, because sentencing is where I had to decide not just what was legal but what was right. Subscribe so you do not miss what I decided. I am getting to it now. I am ordering you to pay a fine of $225,000 to the Marcus Webb Cardiac Recovery Fund, a trust established by his family to cover his ongoing medical expenses and lost income during rehabilitation. His documented medical costs over the projected course of his adjusted care plan came to $180,000. The additional $45,000 reflects the permanent damage, not as a punitive arithmetic, but as an acknowledgement that some things cannot be undone, and the person who caused them carries a responsibility to the person who lives with them. I am also ordering the suspension of your driving privileges in the state of Connecticut for 18 months. A person who chose to keep a vehicle in place when a helicopter needed to land has demonstrated that their relationship to that vehicle requires a period of adjustment. 18 months. That is what I am ordering. I am ordering 400 hours of community service to be completed at Hartford Hospital's Cardiac Rehabilitation Center, not general volunteer work. Specifically there, you will work alongside the staff and alongside the patients. You will understand, in a way this courtroom cannot fully teach you, what the aftermath of a cardiac event looks like from the inside of a hospital. There is one more thing. You will write a letter, not fewer than 500 words, reviewed by this court before submission, to the Sycamore Ridge Country Club membership, to be read aloud at the next general membership meeting. In that letter, you will describe what you did on July 14, 2023, what the consequences were, and what you believe your responsibility is to the people around you in an emergency. You will not have your attorney draft this letter. I will know if you do. And you will pay for Marcus Webb's physical therapy costs in full for 3 years, paid directly to his provider on a quarterly basis. The first payment is due in 30 days. Here is what I said to Vanessa Alcott Pierce directly in that courtroom, and what I am saying again now. You had one moment to do one thing: move a car. That was the full size of the ask. 11 minutes became permanent damage to a man's heart. Not your intention, your decision. Those are different things, and the law treats them differently, and so do I, but the outcome sits between them regardless. To your family, who I saw in that gallery and who did not make this choice, I am not asking them to carry this. That is not what this ruling is for. You come from a position that carries real advantages. I do not hold that against you, but advantages do not reduce obligations. They extend them. When you have more, you are more able. And when you are more able and you still choose less, that is what I am here to address. I ordered 400 hours in that rehabilitation center because I believe that is where understanding lives, not in a fine, not in a suspension. In the faces of people who are learning to walk again and breathe again and live again after something went wrong that did not have to. Thank you for staying with this. I mean that. I know this is a long story. Subscribe if you have not yet. You already know why you are still here. When I returned to my bench briefly after the room began to empty, I had forgotten a folder, which is not something I usually do. I saw Marcus Webb's wife standing near the side door with her hand flat on his back. He was facing the wall, not crying, just standing with his head slightly bowed. She said something I could not hear. He nodded once, then they walked out together. The appeal was filed 43 days after sentencing. It was heard by the Connecticut Appellate Court. The ruling came back 11 weeks later, upholding both counts and the full terms of sentencing. One sentence in the appellate ruling said, "The lower court's application of Section 53A 106(7)A to the obstruction of a registered emergency landing zone is consistent with both the plain language and the legislative intent of the statute." I was not surprised, but I was relieved. Those are two different things, and I have learned not to confuse them. I heard in March of 2024, through a colleague who knew someone at Hartford Hospital's cardiac unit, that Vanessa Alcott Pierce had completed her first 60 hours of community service. I also heard that she had arrived at 7 in the morning on 3 of those shifts before she was required to. I'm not going to tell you what that means. I am just telling you that it happened. Marcus Webb, as of the last information I received, had attended cardiac rehabilitation twice a week for 11 months. He was cleared to return to limited activity. He played 9 holes of golf in October 2024, not at Sycamore Ridge somewhere else, with his son. I heard that from his wife, who sent a brief note to my clerk's office. It said simply, "He finished the back 9, he wanted you to know." There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I am ready to tell them. The question this case left me with is not complicated. It is just this. How does a person hear the words medical helicopter and keep walking back to the lounge? I am not asking it rhetorically. I have genuinely tried to understand the mechanism. What does a person have to believe about their own position, about what they are owed, about who counts when things go wrong, for that to be the choice they make? I have thought about it long enough to have some partial answers, but not the complete one. What I do know is that the capacity for that choice does not live only in luxury cars and country clubs. I have seen it in small claims court. I have seen it in custody cases. It is not a wealth problem, it is a proximity problem. The further you are from the consequences of your choices, the more insulated, the more buffered, the easier it becomes to stay in the lounge. That is not a lesson. I am describing what I have watched happen across 22 years of sitting where I sit. To the people watching this who have been in Marcus Webb's position, not necessarily a medical emergency, but any moment where something happened to you that did not have to, because someone with the ability to stop it decided their comfort mattered more than your safety. I recognized something in his face when he sat in that chair. I have seen it before. It is not anger, though it has every right to be. It is the exhaustion of having to prove that what happened to you was real. When that face comes into my courtroom, I see it. I see the cane. I see the shoulder that does not sit right. I see the suit jacket that almost fits. I see all of it. To the people watching this who recognize something of themselves in Vanessa Alcott Pierce, not the extreme version maybe, but the smaller daily version, the moment where you had the ability to do something and found a reason not to. I am not here to shame you. But I want to ask you one question. Actually, not rhetorically. What would it cost you to move the car? Not financially, not in time. In terms of what you would have to admit about how important that car, that spot, that comfort is compared to the person who needs something from you right now, that is the question I could not ask from the bench. You can ask it yourself, today if you want. It is not complicated work. It is just uncomfortable. There was a photograph on the evidence table, 8 by 10, printed on plain paper. A white Porsche Cayenne parked across a flat gravel clearing, and 40 feet back, a man on the ground, 3 people kneeling around him trying to keep him in the world. The car and the man in the same frame, 40 feet between them, and a choice that sat in that distance. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. The comments are where people who care about the same things find each other. I will be there.